First District Court of Appeals, 9th session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Good morning. Please be seated. Welcome to the First District Court of Appeal. We have one case on the docket this morning. It is Edward and Linda Huck versus Kenmore Commons Home Association et al. Counsel, are you ready to proceed?
I'd like to reserve 3 minutes for rebuttal, please.
So noted.
May it please the court, DJ Fredericks appearing on behalf of Ed and Linda Huck, the appellants we have here today. We're here on an appeal seeking reversal of a partial final summary judgment in favor of the members, which is the AAL, as well as we're seeking direction for summary judgment in favor of the Hucks, my clients, in the lower court. There are 4 main points at issue here to discuss, and each of them will be outlined as we go forward. The first deals with the plaintiffs and the association members lack standing to enforce the Killearn Declaration over a public roadway. The second issue is that Article 8, the article that they're seeking to enforce, is ambiguous and unenforceable. The third and fourth are intertwined insofar that the argument is that the Hucks are not members of the association, therefore they cannot enforce the declaration over the Hucks. And the fourth issue relates to request for admissions, in our opinion that the court erred in not allowing amendments to the request for admissions. The pertinent history regarding this case is as follows. The members are owners, board members within Kenmore Commons. My clients, the Hucks, live in the area to which the declaration controls and the association is established within Killearn, the association. My client, Ed, is a 75-year-old former police officer. He is disabled, and Linda is also unable to...
Counsel, do you take any issue with the nature of the remedy that was granted, an injunction versus, I don't know, enforcement of a fine? Like, do you have any issue with the form of the remedy, or is it just the basis for awarding any relief at all?
Well, the form of the remedy, they're seeking an injunction that the caretaker cannot park on the street, which leads to the issue is my clients have vehicles, including a classic car, and they'll have
well, the caretaker's not enjoined, right? I mean, the caretaker's not a party to this action.
Correct.
So the caretaker's not enjoined.
Correct.
Your clients are enjoined.
My clients are enjoined from allowing the caretaker to park on the street, which is the nexus where my clients have to remove or store their cars off of their property, the driveway or in the garage, to some other location so the caretaker can park on the driveway. So that's their injunction that they've received.
What would happen if your clients failed in convincing the caretaker to not park on the street?
I expect that they would seek sanctions against my client, perhaps contempt for not allowing the caretaker to park in the driveway.
But the injunction doesn't require them to allow the caretaker to park in the driveway.
The injunction requires my clients to not, they cannot allow the caretaker to park on the street, but they need to take action to open it up for them to park in the driveway.
Well, is that what the injunction says?
That the injunction, it grants the declaratory relief that my clients are in violation by preventing them from parking in the driveway.
Well, the injunction says that your clients cannot park on the street and they can't allow or force someone else to park on the street.
Correct.
So how would your clients prevent the caretaker from parking on the street?
Well, that leads to another question.
I mean, is it force of argument? They have to beg and plead or fire her, I guess.
That would be an interesting issue that they'd have to deal with, I think. You know, in the lower court, if they were to enforce this, how would they enforce it? And I would think that's how they would do it. The caretaker is not a party to this case. There is not an injunction against her from parking on the street. But I think the nexus between my clients, the association, that's also part of the issue that I have to argue as far as the ambiguity of this declaration in parking in the street. How can you prevent somebody from parking on the street if it's not even part of your area to which you own or have any dedication or reservation over? So Ed and Linda Huck, they have the caregiver, and the issue is that the association, the members sought an injunction and received one.
Does the record reflect what the nature of this relationship is between your clients and the caretaker or caregiver?
Yes, it does.
Is it pursuant to insurance? Is it contractual? I mean, what is that?
As I understand, there's a contractual relationship between my clients and the caretaker, so that they can remain in the house. Ed is more or less disabled and unable to drive. He cannot get around the house without aid. And Linda is also unable to take care of somebody in that condition. So it's a contractual relationship between them and the caretaker.
Is it a direct relationship between them and the caretaker, or is it a company? Did they reach out and find this caretaker?
As I understand, it's a direct relationship, but I don't believe the record specifically outlines that relationship, though.
Miss-
So the issue related to the parking on the street is that the street itself is deeded to the city of Tallahassee. The association doesn't own it. There's no dedication to the association. There's no reservation. There's nothing that says the association has any rights to control what happens on that street. And that's actually admitted by the association and the members in their discovery and response, and specifically stating plaintiffs do not claim the right to maintain, operate, or control what occurs on Colonial Plaza Drive, which is the street where the caretaker parks.
Well, they're not trying to maintain or control the street. They're just trying to maintain or control what their homeowners can do on the street, it seems to me.
My argument is they're trying to maintain or control what occurs on that street.
Could I have a narrow street. If my neighbors constantly park their car on the street across from my house and I didn't like it, could I contract with them to please don't park your car on the street and I'll give you $100? Is that enforceable because it involves a public street that I have no control over?
Yes, because you have privity with that specific person. This one, the
There's no
reason why.
privity between the homeowners and the homeowner association?
Well, here's the issue with that. The association is a creature of statute, and the statute provides that the statute allows what an association can do, and the declaration provides what the association can do on behalf of that particular area. And the statute 720.303 limits the powers of an association and what members of that association can do. Because of that, that's where there's a distinction between a person-to-person contract where I have an issue, you have an issue, well, let's negotiate it. This one is the statute creates the association and says here's what you can and can't do. And that's why there's a distinguishment there, because the association's powers are limited to common areas, places where there's a reservation, places where the association has specifically been allowed to.
Doesn't
take
the
action.
statute specifically say that it's not limited to those things?
No, it does, I'm sorry, excuse me. It does say that, but there are limitations within the statute that talk about the associations, that the common areas, plumbing, roofing, and common property. The counter to that is if they didn't list out the common areas, plumbing, or common property, things that they are directly responsible for, why even have those limitations? Because if they don't have those limitations, then it's carte blanche that the association can limit anything they want to beyond what the common property is, beyond what was reserved to their jurisdiction, if you will, for what the association can and cannot control. And that's the issue. And that's also
Does the association have this particular sub-association, does it have any common property at all?
yes, as I understand, there are common areas within the association. I don't think that's part of the records exactly, but this was limited to that one particular area, but I believe it does. And I don't have the record to reflect that. So the point is that the governing documents in the statute 720.303, it dictates what can and cannot happen on behalf of an association. Otherwise, the association will be able to negotiate and contract over everything. And the point of an association is to maintain that area to which they have been allowed control over. And usually there's a public dedication. Usually there's some sort of retaining of fee simple or some other ability to bind those types of streets. That didn't happen here. That's why this one's a little unique to what happens generally in a development, is that the city of Tallahassee acquired fee simple before the association was established. That was gone. That was out of any sort of control that they can do anymore over that particular street. And that's why.
Is Article 8 of the covenants, is it utterly unenforceable?
In this situation, I believe it is. And the
Well,
reason
what
why,
situation would it be enforceable, this
Well-
particular provision?
if the language was more clear, there is no overnight parking. You cannot park a car for 3 days in a row. You cannot park a vehicle more than 15 days in a month. I've seen all those restrictions. Those are clear.
Now, just to be clear, Counselor, what does the record evidence show about the parking here at issue? It essentially it's 24-hour attendant care in-home. Is the car out there for 24 hours
Well,
on the
that's
street?
the issue, that's the problem that we have, Your Honor. The members who are also board members of the association, I deposed them and asked them that question, what is the problem? What did they do wrong? And none of them had an answer. All of them had a different varying, it's there all the time, it's there most of the time, but generally all of these words will apply. Well, I asked each of them, what do these words mean? And nobody can define those words to me. And they couldn't define them on the record, and I also showed them at the deposition, and this is part of the record, 3 different situations where cars were parked at different times, days, hours, overnight, before morning, and all of them had a different answer as to whether or not those were violations.
That seems to undercut your primary position, which is, I thought your position was that the HOA doesn't own the city streets, so there's no enforceability. Why does it matter whether, you said it would have been enforceable had it been like 3 days, or, you can't park for 3 days, or you can't, I don't know, some of the other examples you listed. Why even go there?
Well, it's defense. The first defense is that you don't have any control over me. You cannot control over the street. If you can control over the street, this provision doesn't work because of these issues. So it's generally, you don't have control over me over the street because the street's not under your purview. If you did have control over me over the street, then the limitations you have over me should be clear and unambiguous. And based on the information part of the record, they never were able to define any of those terms. Multiple different declarations, I read through them, examples of clear terms, no overnight parking for 3 days in a row. That is a clear, unambiguous term. This one, the problem is it's ambiguous insofar as that they cannot apply it to this particular set of facts. And the case law outlines that it's well settled that the declaration should be strictly construed against an author of the declaration, and that is here the association, the members that are seeking to enforce that. And just briefly, before my time runs up for the initial arguments, the third and fourth issue relate to the request for admissions. It's my opinion that the lower court erred in not granting the ability to amend. The reason being is the request for admissions were admitted that my clients were members of the association. Through additional discovery and review, it was discovered that there are issues with the plat and that my client was never part of the association, therefore they were never members of the association, and we sought to amend those requests for admissions. At this point, I'd like to reserve the rest of my time.
Good morning, Your Honors. Thank you. May it please the Court. My name is William Hall. I have the honor today of representing the Appalese, the Kenmare Commons Homes Association, as well as the individually named plaintiffs. Clearly, we are asking you to affirm the order. I will address the issues that Mr. Fredericks raised, as well as that were raised in the briefs. I do want to start quickly by responding to one question you had, Judge Nordby, and then quickly to kind of the initial colloquy you had, Judge Tannenbaum. Judge Nordby, as to what the record reflects as to when the parking occurs on the street, if you look at the interrogatory responses from the plaintiffs, they stated that it is a 24-hour caregiver, as you stated, and I apologize, I do not have the page number in the record. I apologize for that. But the response was that at all times while providing care, that car is parked on the street. So can we sit here and say the car never goes to take out food or something like that? No, but per the record, at essentially all times, that car is parked on the street when 24-hour care is being provided. And as to that initial colloquy, Judge Tannenbaum, as to whether we have the right remedy here, I would just note the appellants never raised as an affirmative defense, never briefed in this case the issue of remedy, never argued that the caretaker was an essential party who should have been joined, an indispensable party. I would submit to you, I don't believe that issue is before the court. I don't believe the court should inject that into the case. If the court does believe it's appropriate to consider, I would note that the Lake Dexter Woods case, which we have cited to, I believe, in our answer brief and in the record below, stands for the proposition that a homeowner is responsible for a guest or tenant, and this is a live-in caretaker
Oh,
for their
but we're not
actions.
talking about what he or she does in the house. We're talking about what he or she does as an independent Florida citizen and maybe even resident of Leon County and the city of Tallahassee to park on a public street. And so my question really wasn't so much about whether it's the right remedy. I'm trying to understand how that injunction works ultimately. So they tell this, this contractor, please don't park in front of our house. And he or she is concerned about safety at night. I don't want to walk down the street to the Shell station to get my car. I'm going to park on this public street anyway. Are they going to be held in contempt then?
Two points, if I may, Your Honor. The first would be the Hucks would be responsible for the actions of their caretaker. But let's go to why are they parking on the street from the record. The reason they're parking on the street is because they have no other option, because the Hucks have a car they drive.
Well, they have plenty of options. They can park down the street. They can park at the Shell station. They can park a mile away.
The reason the Hucks are not giving them the ability, if they want to walk a mile, they're free to walk a mile. That would not violate the covenants. This parking violates the covenants. The problem-
Where in the covenants does it require a homeowner to vacate part of their garage to allow someone else to park there?
What it states in the covenants is that continuous, regular, and permanent on-street parking is not allowed. The Lake Dexterwood case stands for the proposition that as a homeowner, they're responsible for their guests and tenants' parking. They have 2 unused Corvettes that take up the majority of their parking. They've chosen not to sell them, that's fine. But they are forcing their homeowner onto the street. That's the issue we have here. There are 2 other, I think, let me also back up a second.
Which,
I'm sorry.
Article 8 reference, no car shall be parked on the street. So which street?
Your Honor, clearly that goes to the street running through Kenmare Commons.
Why is that clear?
Your Honor, the King versus Bray case that we've cited to states that if there's 2 possible readings of a contract, one which is preposterous or absurd and one which is reasonable, the court very clearly has to side with the reasonable reading. To say that you can't park on the street means you can't park on Capitol Circle and that's all the way across town would be an absurd reading.
Why would that be absurd?
Your Honor, because this is regulation of the homeowners association. What is a homeowners?
And that's where I wanted to go. So, yes, what is the HOA trying to regulate here?
It's community. It's trying to regulate its community. That's what a HOA
Well, what is the community?
The community is all of the people living together, all of the property. And they have decided by contract to contract with each other that we will not park in the street in what, as Judge Winokur noted, in a narrow street can cause issues. And that's in the record. It's in the record that there
Is the HOA responsible for regulating that street?
It is not responsible for regulating the street, but it
So
has.
why is it trying?
Because it is contracted with its members to prevent on-street parking because if, as stated in the record, if everyone were to park on the street, and we've had in the deposition testimony it stated, a school bus, a garbage truck, an ambulance cannot get through because
But
it's
isn't that
narrow
a
street.
city of Tallahassee concern?
No. If
Why?
an ambulance can't get to their house, that's their concern.
Well, I know, but, I mean, it's a city of Tallahassee street.
Your Honor, this really goes to the freedom of the right to contract. Is there any encumbrance on the right to contract of Florida homeowners associations that is not found in statute? I say there is not. There is no encumbrance on that constitutional right that says they may not contract with each other to say, we all agree we will not park on the street for regular or continuous points of time.
Well,
That's
isn't-
what they've agreed to.
Isn't there a difference, though, between a restrictive covenant and a contract? I mean, a contract in the standard sense where you and I come to a meeting of minds, we have consideration, and you agree to do something, I agree to oblige myself to do something, or, or something like that. Isn't there a difference between that and a restrictive covenant that runs with the land?
There's a difference in that it is a form of contract, but it is a contract. It is a different type of contract. It is one that runs with the land, that affects the use of property, but it is a contract that is interpreted as a contract.
So
And
how is this property being used contrary to the covenant?
there is parking on the street for regular.
But that's not their property and it's not the HOA's property.
It's, Your Honor, what we're talking about here is a breach of contract. The covenants and restrictions are a contract. They have breached that contract by doing what the covenants say they may not do. That's what we're talking about here. It's not about a public road versus private road. It's about contract versus not. If this court were to find that the Hucks, after having agreed to this, not only just by moving into the house, if you look at their mortgage document, which we pulled and which is in the record, they expressly agreed we will follow the declarations as part of their mortgage. They expressly agreed to this. They're also former presidents of the association. Now that they actually have to follow the contract, they say, well, actually, we just don't want to because it's a public street, so you can't make us.
Well, they're not saying they don't want to. They have an independent contractor who's choosing to use a public street. So, I mean, get back to that for a second. Doesn't the attendant care provider have an independent right to use the public street any way he or she wants?
He does. But the problem for the Hucks is that they have contracted that they, and again, pursuant to that case, which if this is an issue as to form and as to the tenant, I think that frankly may require supplemental briefing if the court is going to interject that position. They are responsible for his actions. So it does not create an issue for him. It creates an issue for the Hucks because of the rights they've contracted away voluntarily, as with any contract. Your Honor, as to the issue regarding what's been stated as an ambiguity, I would say it's actually not an ambiguity argument at all. It's a vagueness argument. If we were talking about ambiguity, that would mean, well, there's two possible readings. It could be one, could be the other. But what possible reading could the Hucks give you in which 24-hour around-the-clock parking is not regular, sustained, or permanent? They can't. What they're basically saying is this is a meaningless provision, that having this provision in the covenants is the same as having no parking restriction at all. Clearly, that's not a reasonable reading of the covenant. It's not. We have to give effect to that as we would with any contract language or any statutory language.
How far off property could an HOA enforce personal behavior of a homeowner?
It depends on the contract, Your Honor. I'll give this hypothetical. Let's say I, wanted to start a homeowner association and said, I love the color blue. I want everyone to have blue houses, and I want everyone to wear the color blue when they're in our common areas, maybe even outside. And everyone who lives here is going to agree we're going to do that because we believe we love the color, we believe it improves our life, it improves the aesthetics of the community, what have you. The right to contract allows us to enter into that agreement. The whole point of that right is that the government, it's not for the government to tell people what's a good deal for them and what's not. It's for them to decide for themselves. There's a very, very limited portion of Florida statutes, 720.3075, which states these particular provisions may not be in an HOA covenant. That's it. And anything about parking on the street is not there. So hypothetically, if I went to buy a house and they said, we're going to restrict your ability to park anywhere in Tallahassee, I would have the right to accept that, or since I have a car and need to park someplace in Tallahassee because I live here, not live in that house.
Well, go back then, you acknowledge that there's a difference between a restrictive covenant and a regular contract. What do you think those differences are?
The main difference would be it affects the use of the property. That's really what a restrictive covenant does.
Right.
It says you may not build a dock on this land, you may not do whatever it is. That is generally it's how can I enjoy my property, use my property, how can I live in this community? That's generally what a covenant is. That does not limit the right to contract for, you also may not park on the street, you have to paint your mailbox a certain color. There's any number of.
There's not a separate contract here, though. We're just talking about restricted covenants. So I'm trying to understand how you shoehorn in the idea of contract, which, like, okay, I pay you $10 and you're going to wear blue for the week, versus, hey, I bought this house 20 years ago and it had this list of restrictive covenants that was recorded on the property. My understanding of restricted covenants as the homeowner is that it restricts my use of the property, and I'm willing to restrict my use of the property to conform with these restrictions.
Your Honor,
I didn't know that when I was buying the house that I was also going to give the HOA the authority to regulate my behavior off property.
Your Honor, they did know because it was stated specifically in the covenant. It would be like if they said, I didn't know for my mortgage I had to pay my payments. It was stated specifically in the contract they agreed to.
But your argument is premised on the idea that, well, restricted covenants are just like personal contracts. And so it doesn't matter whether it has nothing to do with the personal use or the use of the actual property subject burdened by the restriction, it's enforceable. And I'm trying to understand how you would say that if the privilege of a restrictive covenant and why it's treated differently is because it's recorded and it regulates the use of that particular property.
Your Honor.
You're trying to expand it to include other things, even though there's not consideration, there wasn't a meeting in the minds between the two parties of this ostensible contract.
I'm not sure where, there's certainly, I believe, no record evidence of no meeting of the minds here, but I would say this, I am not interjecting contract law into HOA law any more than Florida law always has. As I'm aware, every court that has interpreted a homeowners association covenant and restriction has interpreted it using contract principles. I do not disagree it is a unique type of contract. But if this court were to say, we are now taking away from HOAs the ability to contract for something like on-street parking, respectfully, you would be doing so with no support in statute, because there is nothing in Florida statute, nothing in the right to contract law that would support that whatsoever. I see my time is starting to run low. One last point I believe I've not touched on, the issue of association membership. To be frank, as we came here today, I was not sure if that had been abandoned coming in because it was not addressed at all in the reply brief. Even after in our answer brief, we made very clear that the basis for the order on the admissions and the refusal to allow the Hucks to switch their position was that they were judicially estopped. But in the initial brief, judicial estoppel was not addressed at all. So I frankly don't know that issue is truly here before you and has not been fully waived. If it has not, we keep hearing, or it's been stated in the briefs, and you've heard today that, oh, well, there's been some evidence in discovery showing that actually we're not members. To the contrary, almost all of the evidence shows they are members, including some of the evidence that the Hucks gave in their summary judgment motion. It's frankly one of the first cases I've ever seen where in moving for summary judgment, a party gave evidence supporting summary judgment against them. In the affidavit from Mr. Huck, he states, the association will not allow me to expand my driveway. If he was not a member of the association couldn't allow him or prevent him from doing anything. They also offered the unrebutted that they are dues-paying members and former presidents of the association. There's also the unrebutted testimony, and as your honors are aware, there is a burden on a party. Once one party moves for summary judgment, offers evidence, the other party needs to offer counter evidence. They've offered nothing to counter the mortgage document, the other public records we've submitted to show that it is part of Kenmare Commons, as well as the counterclaim that was filed that was predicated on their membership. And your honors, with that, I would simply ask you to affirm unless there are any other questions.
Just
Yes,
one
sir.
more. And I know the statute, we talked about this, you made reference to it already, the idea that the homeowner is responsible for the activities or responsible for tenants, guests, invitees. Isn't a fair reading of that, though, that they're responsible for what they do on their own property? And so, like, if they leased out their property to someone else, and the tenant, adds something that's inconsistent with the plans, or if there's a common area and that invitee goes out and they deface that common area, the reference to being responsible for the invitee, wouldn't it be limited to just that, including their behavior on property that's burdened by the covenants?
No, you're right. I believe it would be limited to, and I'm going to the sections, as was discussed somewhat earlier, 720.303 talks about the powers of the association. I see my time is up. If I may just briefly finish the answer.
You may finish.
Yes, thank you. The powers include those relating to common areas, but are not limited to those of the common areas. They also relate to the governing documents. And that's what we're talking about today, is a provision of the governing document that has been violated, and that they are not only allowing, but forcing their 24-hour caretaker to violate. That's the issue. Thank you, Your Honors.
Mr. Honors, may it please the court? Just a few points to go on. Just Tannenbaum, you asked how far off can these declarations restrict parking on a street? And that's exactly the point that I'm making, is that the association and these documents and these declarations are creatures of statute. There was no negotiations between my clients and the association in drafting this document. These are declarations that were created pursuant to what the association is statutorily limited to create and what they can create over. And that's defined as a common area in 720.301. It talks about all property within a community which is owned or leased by an association or dedicated for use or maintenance by the association or of its members. That's the point, is these declarations, which are in the nature of a contract, but they're not a negotiated contract, or have these restrictions. There's a finite area and limitation to what they can apply over, and that's defined in the statute. So to say that there are no limitations is ignoring what these statutes have been created for. Otherwise, what's the point of having these definitions within these statutes in Chapter 720? Otherwise, they can do a carte blanche contract that I have to become a lawyer to live in this community, or I have to drive a white car while I'm not living in the community. I mean, those are all portions that are limited by these statutes, and that's the point of these statutes.
This would be a different case if the developer hadn't deeded away all the streets to the city of
Absolutely.
Tallahassee, right?
Absolutely. There would be a completely different case. The argument wouldn't stand, had no legs to stand on, because, and that's usually what happens, is the developer maintains or creates a dedication to the association or doesn't deed away fee simple to some third party when they create the association. And that's what happened here. And that's why this case is a little unique than what usually happens generally in the creation of an association.
So is your point, your main point, that it's not so much the Article 8 itself as much as it's, well, that would be very interesting if the HOA still owned that property, which then would be considered common area type stuff, where then the HOA would be able to regulate it? Is your main point is once they gave away, you know, the HOA's authority under the restrictive covenants is limited to the properties and common areas that the HOA, that are burdened by the covenants?
Correct. That's the main point. I know my time's running up, but just briefly, if I may, Your Honor.
You may.
The space here is defined by statute. This is what the association can control. You cannot control what happens on the carpet. And that's the general analogy for that. Ambiguity, there was a discussion about ambiguity, and it means two different things. Well, that's exactly what happened here, is that the members said that this actually means 5 different things. The different sustained, regular, periodic parking. All of them mean 5 different things, and that's all part of the record. So with that, Your Honors, I do appreciate your time and would request that the summary judgment be reversed and entered in favor of my clients.
Thank you for your arguments, counsel. This concludes our docket for today. We are adjourned.
All rise.
I